Our next panel is going to be about sharing the benefits to and the barriers to sharing behavioral health information. It's going to be led by Professor Tara Ragone. She's from Seton Hall Law School, and she's going to start us off with a presentation that gives an overview of the behavioral health landscape, after which she will moderate a panel discussion. So I'm actually going to invite Tara and all of the panelists to the stage and read you their bios as they come up so you know who's who. Tara Adams-Ragone is an assistant professor in the Center of Health and Pharmaceutical Law and Policy at Seton Hall University School of Law, where her research and writing currently focuses on the integration of behavioral and physical health care and mental health parity. Corey Waller, who will be on the panel, is an addiction, pain, and emergency medicine specialist, a principal consultant at Health Management Associates, and the chair of the Legislative Advocacy Committee for the American Society of Addiction Medicine. He will be on the panel, and he will be joined by Pamela Greenberg, who is president and CEO of the Association for Behavioral Health and Wellness, and also Adam Hepworth, who is an associate and healthcare business lawyer with Foley and Lardner. Please help me in welcoming Tara for her presentation in the panel on behavioral health.
Thank you. Seeing where is this the clicker? Yes, great, okay. Good afternoon. I recently presented a very long CLE, a continuing legal education class on part 2. And so now coming in here and trying to do something quick, just like a foundation, I'm having a little transition problem. So I need to move quickly through this because I think the dialogue of the panel is going to be the most interesting. But we wanted to start off this session with a little bit of a baseline on what Part 2 says and what it holds, and then a little bit about Michigan laws as well. So let's see where we... So what I hope to do today is a very brief contextual introduction to why I care about these issues, the work I do in behavioral health integration, then some highlights of Part 2 to make sure we all are conversant for the conversation to follow, a brief overview of some Michigan laws that also are in this area of substance use record, confidentiality, and then we almost certainly will not get to some hypos that are focused on federal law, but they were in a fairly recent SAMHSA presentation. And I always think it's helpful to ground this in specific examples. And so I basically just rewrote what SAMHSA put on just to make sure that you can trust this. This is coming from the regulator. It's not me giving you an opinion of how I think the regulator would interpret the law. So to the extent you want to see some examples of how these various regulations play out, might be worth flipping through those materials. So don't worry, I know we're not getting through 100 slides today. All right, so why am I in this area? I'm not a tech interoperability, privacy guru. I'm a health systems person doing a lot of work in New Jersey, in particular about behavioral health integration. And despite consensus for at least a decade that the gold standard should be integration of behavioral and physical health care, and despite grant dollars from private foundations as well as government agencies to support the integration, we found in New Jersey we were having a very hard time integrating, and we weren't alone. There are states throughout the country that were having this problem. And so we did a fairly in-depth analysis of New Jersey law and uncovered a lot of confusing and conflicting and ambiguous laws in New Jersey that were impacting on this. People were all talking about HIPAA, but that really was more than HIPAA. And then last year, I did a similar work for Michigan to look at what Michigan's laws, how they impact, and that's a report that came out last year. So that's how I got into this, and we want to realize that there are a variety of barriers to integration, including financing to be able to do it, and including licensing rules that sometimes make it difficult to license a facility to provide different services, information systems that were out of date, misinformation culture, but we also found that the privacy laws themselves were serving as a barrier to integration. And so we want to get the siloed records to be integrated to provide care for individuals as a whole person and for all the different issues that they might have that they need to have treated at the same time to be effective. Okay, so Generally, when you're talking about federal law in this area, it's usually HIPAA and then what we refer to as Part 2. There also are other laws that impact privacy, can impact, so FERPA is a law that deals with education records, but we're going to focus today specifically on Part 2 because it was thought that not everyone is as familiar with the Part 2 requirements. And so please know there are some other provisions and other laws. We're hoping that HIPAA is more familiar. We don't need to do that today, but we'll focus on Part 2. What is Part 2? It's kind of a strange name. Part 2 refers to a section of the Code of Federal Regulations, and those are this particular part of the Code of Federal Regulations is implementing a statute that established heightened confidentiality protections for substance use disorder treatment and prevention records. And so the statute was pretty short, and the implementing regulations got into more of the nitty-gritty details, and for some reason that's how everyone started referring to the governing law, just as Part 2 requirements. So that's where we're getting this from. So the impetus for this law was a concern that there, with substance use treatment records in particular, that there is discrimination and stigma that can have real impacts on patients, can lead to criminal consequences, it can impact child custody, it can impact your employment, and those real potential outcomes of the stigma and discrimination can also then discourage or deter patients from seeking help for their addiction. And so there wanted to be a policy of let's protect patients from these potential negative consequences to encourage them to seek treatment. And so these laws were to be more restrictive, more protective of privacy in service of that goal. So generally, in order to disclose records of substance use treatment, and we're going to get much more detail than this, there are certain kinds of records that are protected. Generally, you're going to need written consent, which is unlike HIPAA, where there are many more exceptions. And so we're going to go through this framework to see what does Part 2 apply to and what are the limited exceptions, and how we'll do a little bit of a contrast to what HIPAA covers and how HIPAA has more extensive exceptions that work to support integration of care and the sharing among treatment providers. So this is the language from the statute. So again, it talks about records of the identity, diagnosis, prognosis, or treatment of any patient maintained in connection with the performance of any program or activity relating to substance abuse, education, prevention, training, treatment, rehabilitation, or research. It has to be assisted by any department or agency of the United States. These records are confidential and may only be disclosed as provided in the statute and the implementing regulations. It's important to note that this statute does not require disclosure, it instead permits disclosure. So what the statute and regulations talk about being a permissible disclosure, the entity that possesses those records are not obliged to release them. It's not like a court order. These are permitted disclosures. This is a semi-endorsed framework from a 1975 article that SAMHSA recently included in a presentation. So again, it seems blessed for how to analyze Part 2 questions of applicability. So first you want to ask whether or not the information is protected by Part 2. And then we're going to go through different steps in an analysis for what counts, and if it in fact is covered by Part 2. So HIPAA is about protected health information of patients, and it applies to certain possessors of that information, right? So covered entities. With Part 2, it's a Part 2 program that has substance use treatment information. And so you have to do an analysis of whether or not the entity that has the protected information is covered by the statute, and we're going to go through what makes something a Part 2 program. If the answer is yes, then you look in the statute and regulations for any exceptions that are permitted to the general confidentiality requirement. You also then see if a patient will consent, because the patient can then consent in writing to the disclosure. There also is an option under Part 2 to get a court order for the release. So I'm going to go through the next few slides very quickly. They're just there to give you a flavor for the breadth of this statute. There are some ways in which Part 2 is actually narrow. We're going to talk about what it means to be a Part 2 program and to be federally assisted. These are requirements in order for Part 2 to apply to records. But also there's some language that's kind of broad, right? So seeing that language and seeing how it might impact folks who possess these records or possess records that might qualify as these records and get nervous and worried, and we'll talk about that, about perhaps overly restrictively interpreting this language out of fear of consequences being found in violation. So just to see that the coverage of diagnosis includes conditions that were caused by a substance use disorder, so not just substance use disorder as a diagnosis. Disclosure is any information, even if it didn't originate from that program, even if it's verbal. It doesn't have to be recorded in writing. Examples of disclosure, it's broad. It's not just handing over copies of medical records. It's testimony, sharing written records, sharing patient identifying information in a way that a patient may be re-identified. It's submitting claims to payers. That counts as disclosure. These are examples of treating provider relationships, the definition in the regulations. So it gets to the breadth of, even if you didn't actually treat the patient, but you agreed to treat the patient, maybe the patient never showed up, that still is going to be a treatment-provider relationship under Part 2. But SAMHSA, I just note for a side note, given the integrated health angle that I come from, SAMHSA recently declined to expand the definition of treating provider relationship to include a care management relationship. So it is dancing around how to draw the line between we want to protect this information, but we also want to encourage a holistic care of patients. I think I already referred to this, a definition of record, whether or not it's actually in writing, whether it's produced by the Part 2 program, or whether it's received by them, given by a patient's sibling, whatnot. Those are still considered to be records. I think this is rather like a summary of what I just said already. Just again, the breadth of the coverage with respect to what kinds of records are covered by Part 2. So here we have, again, a part of the regulation that it talks about restrictions on sharing protected Part 2 information. And the very important limitation is that whenever something is disclosed that are Part 2 protected records, there's a limitation on the scope of what's produced. It must be necessary to carry out the purpose of the disclosure. So we're going to talk about limited instances, limited purposes that permit disclosure, and then the disclosure itself has to be tied to what's necessary to further that purpose. And I think why we tend to find that some entities are overly restrictively interpreting this language is that there are criminal penalties for violation of Part 2 and the protection for Part 2. Similar to the Notice of Privacy Practices that we see in HIPAA, patients have to be provided with a summary of their rights under Part 2. Importantly, though, it can be combined with state-required disclosures or HIPAA-required disclosures. All right, so now we're going to get to the two main considerations with respect to whether records are protected, are bound by Part 2. How far does Part 2 reach? There are two main requirements for the records. First, it has to be a Part 2 program. The entity that is maintaining these records, whether it's an individual or an entity, has to satisfy the definition of being a Part 2 program. It also has to be a federally assisted program. If you satisfy both of those requirements, then yes, these more restrictive requirements of Part 2 apply. So program is defined in the regulations in three ways. One, they make this distinction between general medical facilities, which is not a well-defined term, but generally you can think about hospitals. FQHCs oftentimes can be general medical facilities. So the way they define program distinguishes general medical facilities from non-general medical facilities. So first, if it's an individual or an entity other than a general medical facility that holds itself out as providing and actually provides substance use disorder diagnosis, treatment, or referral, that is one way that you can be a program. If you are an identified unit within a general medical facility, so for example, perhaps a detox unit within a hospital, if that unit holds itself out as providing and provides substance use disorder diagnosis, treatment, or referral, That's another way to satisfy a definition of a program. Importantly, though, just the identified unit within the general medical facility is a program, or could be a program, depending if it also is federally assisted, not the entire hospital. So the program, the designated unit, is going to be bound by the Part 2 more restrictive confidentiality provisions, but not the cardiology unit in the hospital. That is not holding itself out as and actually providing substance use. So this is an important distinction when you get into issues with hospitals or other providers that fear that they're going to be bound and they don't want to share their records because they think that they're bound. The reg is much more nuanced than that. It's the specific identified unit. The third way is that you're a medical personnel or other staff within a general medical facility, not within a specific unit. Maybe it's not a whole detox unit, but maybe there's one particular provider or 3 providers who are within this general medical facility, and they hold themselves out. Their primary function is to provide substance use disorder diagnosis, treatment, or referral, and they're identified as such by the provider. By the facility. So you have a person who is identified by a hospital as our substance use treatment provider. They have a name on their office door, for example. They're the designated medication-assisted treatment provider for the unit. Again, that person within the general medical facility may qualify as a program. That's bound by Part 2, but not the entire facility. So important distinctions to know about with respect to Part 2. The second requirement is that there be federal assistance. And this is a little bit broader. It's not just that the particular provider or the particular designated unit within the general facility gets a grant to do substance use work. It's broader than that. The money has to come from the federal government, but it doesn't have to necessarily be used for the substance use treatment. It also reaches certifications. So for example, if you have a Data 2000 waiver that permits you to prescribe buprenorphine as a form of medication-assisted treatment for addiction, you satisfy the federal assistance requirement. If you are a participating provider in the Medicare program, that's another way in which you are a federally assisted program. So again, the facility or the provider has to satisfy both, being a program as defined in one of those 3 ways, as well as being a federally assisted program. Okay, so if you satisfy both of those things, then yes, these various provisions in Part 2 apply to you. And as I said, the default is there's no disclosure without patient consent, except in some narrow exceptions. So let's try to go through some of those. So absent an exception, the default is you need to have patient consent to disclose records. And the regulation is specific that it must be consent in writing, and there are 9 essential elements for that consent. So it's very knowable. So if you are bound, it's not like they're hiding the ball. You can develop a consent form, and you can comply with the law. It doesn't mean you're going to be thrown in jail for violating, there is a way. You have to compare it to other state or federal requirements, like the authorization requirements in HIPAA, and make sure that you're consistent, but there is a way to know what the legal requirements are for the contents of consent. And so we'll go through some of them in more detail. Some are very self-explanatory, like the name of the patient is one of the things that has to be in there. The from whom section, that can be a more general description. It can be a specific name or a general designation of the originator of the records. The amount, how much and what kind of information has to be identified, explicit description of that information. The to whom part of the consent has changed recently. It used to be, and I have a couple slides down, gives more detail. We might, because of time, I can't see the time on that. Oh, I'm too short. Okay. What did it start at? I was too short to see what it started at. It says 70. Did it start at 90? I hope not. It probably did. That's not good. Okay. I gotta go fast. Okay. You're gonna be able to read these slides. Basically, you have to have 9 things for your consent, to whom was recently expanded in a revision of the rules. It had been that you had to identify the specific person or entity receiving records. And so if you had a health information organization, for example, that had people coming in and out, you had to constantly update your consent forms, which was very hard from an operational perspective. Now there are situations, and there's a slide that gives more detail, where you can, in certain situations, have a general description, and that one of the goals of that, a main express goal, was to hopefully have more HIOs, HIEs, and ACOs, accountable care organizations, being able to include Part 2 records. Let's see. So in addition to this is a continuation of the 9 requirements. The purpose of the disclosure needs to be part of the consent form. And again, any disclosure has to be necessary to carry out that stated purpose. Treatment is an accepted purpose. So it can be that you are disclosing for treatment. That can be a permissible purpose to include in the consent form. Yes? Am I? Thank you. Thank you. The screen is very small. I can't see where I am, so thank you. Or I need new glasses. There also has to be a statement that the consent is subject to revocation, and importantly, revocation under Part 2 can be done orally in comparison to HIPAA, where it has to be in writing. It can be an oral revocation. So it is harder. There are definitely aspects of Part 2 that are more difficult for programs to comply with. They have to keep track of the revocations and have a way to implement them very quickly, including an oral revocation. But again, the ball's not hidden. There are ways to know this and then try to build your systems to accommodate. Okay. And this slide now, I think, completes the rest of the 9 requirements, when it will expire, and it can't be, you can't just generally say when revoked. It can't be that broad, but it can be a very long time. It is permissible to say upon death, for example, if that's going to further the purpose. There has to be a link between the time that it's going to extend and the purpose that you're pursuing. And then a signature, and the date. So those are the 9 requirements for a consent form. This we already talked about, so I'm going to go over this quickly and let you read it for more detail. But this is the expansion of the to whom aspect of the consent form, and how the regs were fairly recently changed to expand in certain situations, permit a general designation, which again is aimed to make it easier for larger organizations such as HIOs to include Part 2 records. This is more on the to whom requirement, and again, the various situations, scenarios, and when you're permitted to use a general designation and when you need to have a specific name. An important thing, though, when they opened this up, when they expanded the to whom designation, they also said a consumer, a patient, is entitled then to a list of the people or entities to whom their records were released pursuant to a general designation. So entities have to be able to keep track of, and produce that information. And this is more examples of what general designations can look like. So, for example, you can say your current treating providers. Again, when it's permitted. It's not always permitted, but when there's, and there's a chart we'll get to in a minute, that SAMHSA put together that gives you different scenarios and when you can have a general designation. And so when you're permitted to have a general designation, something like current treating providers is sufficient. If you just say treating providers, there'll be a default that presumes you mean current. You can say former, current, and future, but if you don't, there's a presumption that you mean only current. So this is a chart that, again, as I mentioned, this was from a SAMHSA presentation to the American Bar Association Health Law section. Time? No, one more slide. I still have to go to the slide? Oh, thank you. Yeah, the one on the left is what's showing. Thank you. I saw the chart at the table. And so here this breaks it down, the next couple of pages, whether you're identifying, you're distributing to an individual or an entity, whether there's a treatment provider relationship. Those are factors that affect whether or not you have to identify a specific name or whether you can use a general designation and any other requirements that you must satisfy when you do that. So, for example, if you are disclosing to an entity with which there is no treatment provider relationship, in a narrow situation, when that entity is a third-party payer, then you're allowed to do a general designation. But the next slide then gives you what you do if it's not a third-party payer, you're not satisfying the requirement in the reg, that's when you have other requirements on you for satisfying some more noticed disclosure. So, for example, an HIE in a research institution falls into that other category, not the third-party payer. So that chart you can refer to if you want more detail on that. This is an example of the amount in kind requirement for the consent form, what has to be included, and the person who's signing the consent form has to be presented with some granularity. They can say, I only want to send my lab results, or I only want to send my progress notes. They can also be given the opportunity to say, I want to send all of my substance use disorder information, as long as they were given other more granular options. And so there's been some guidance that helps know what a compliant consent form is going to look like with respect to that. I won't say much about minors today, just given the amount of time that I'm taking to do other stuff. Just know that it's always important in looking with HIPAA Part 2 and then an interaction with state law at what the laws say with respect to when a minor is able to consent or who has to consent with respect to the treatment of a minor. In many instances, it's the parent or legal guardian. But there are some state laws in particular that permit a minor either in conjunction with a parent or sometimes alone. Just a minor's consent needs to be given. And so systems have to make sure that they are tracking and obtaining the consent from the right entities, and it will change based on the particular laws involved, the specific types of treatment involved. And the important thing for Part 2 is that you always do need the minor's consent with respect to the disclosure of Part 2 information. So that's an important add-on to a system that's tracking consents. Whenever information is released pursuant to consent with Part 2, there also is something called a prohibition on redisclosure, and there's a notice that has to be given. The recipient of the Part 2 protected information is prohibited from redisclosing that information, and a notice has to go to that recipient, putting them on notice of that obligation. And it used to be that it was a very long, it was this A1 paragraph on the slide, detailed disclosure that was required. Every Part 2 program had to put that out. More recent amendment, again, expressly to recognize character limitations in EHRs, for example, that there are limited fields available for text entries, approved an alternative, very short notice. 42 CFR Part 2 prohibits unauthorized disclosure of these records. So the entity, the Part 2 program, has a choice between those two notices now. Okay. This is with respect to the redisclosure prohibition. I've lost myself for just a second. I'm sorry. Right. So it's talking about this is continuing the obligation to. Because of this restriction on redisclosure, when you receive these records, there's a real risk that if you commingle the records and you then are asked to send it to the next treatment provider, you can accidentally send records that you're not permitted to redisclose. And so it does put a burden to think about perhaps segregating your records. Okay, so then there's a limited exception. So I think if you're talking about HIPAA, we're going to get to HIPAA in a minute where I just contrast it with Part 2, but the treatment, payment, and operations exception in HIPAA permits release of information for those three purposes, treatment, payment, and operations, without patient authorization. And here, under Part 2, you don't have that exception. And so if a patient gives consent for disclosure of Part 2 protected information for payment or healthcare operations, then there's a limited exception. It permits, normally, that would be the limitation on any redisclosure. You can't redisclose, but for payment and healthcare operations, there is an exception that permits the redisclosure when it's necessary for contractors and the such to carry out that function, to carry out the payment function, for example. And so that's an important limited restriction. Although this has been expanded for the healthcare operations to encompass population health services, SAMHSA has so far resisted including care coordination or case management within this operations definition because they find that has a treatment component, and so that they've kept that where because of the treatment component and there is no treatment exception in Part 2, there needs to be consent for release for those purposes. Okay, I told you the more exciting part's going to be the panel, so I apologize if I'm boring you to tears. We'll try to get through this quickly. now the statute provides some limited exceptions, and I'll go through them pretty quickly. Limited exceptions to having a written consent requirement to disclose Part 2 protected information. So there's a bona fide medical emergency exception, and there's a slide that gives much more detail on it. I won't go through the details, but so that's the closest thing to a treatment exception, but it is very narrow. It's really about in a medical emergency where the information is necessary to treat that medical emergency, there can be a release without patient consent when it's impossible to get that patient consent, not because the patient's refusing, but because it's impossible to get it. There also are exceptions for if you get a court order, also to perform research, audit. Let's see, as I said, the next slide, or next couple of slides, gives more detail about the medical emergency exception, the bona fide medical emergency, and requirements. You have to immediately document. The Part 2 program has to document the release. What was the medical emergency? What was the date and the time of the disclosure? The name of the person making the disclosure, things of that nature. And there has been guidance that clarifies that it does not have to be a Part 2 program that determines that there's an emergency. It's a healthcare provider. It's medical personnel, I think is the language used in Part 2. That decision, though, cannot be made by an HIE. So it can't be made based on some kind of artificial intelligence algorithm that makes a determination. This sounds like, from these findings, there's a medical emergency. It does need to be medical personnel. And this slide, again, gives more definitions and information about what qualifies as a bona fide medical emergency, including what qualifies as medical personnel. And it talks again about, in this case, there isn't. If information is released pursuant to the bona fide medical emergency exception, it does not have, you don't have to, the recipient is not bound by the redisclosure restriction. So it's a very unique exception in Part 2, because normally it's any release with consent has a redisclosure limitation on it, but this was not released with consent, and so far there's no requirement that there be a restriction on redisclosure. Okay, so some other exceptions are communications within a Part 2 program. So for example, you have a substance use counselor and a supervisor, and they need to communicate about a patient for purposes of treatment to try to guide the care. That internal communication can be done without patient consent, and also to an entity having direct administrative control over a Part 2 program. So again, picture a hospital, and you've got a small detox unit, and there's a billing office that provides billing services for the whole hospital. That billing office is outside of the Part 2 program, but it has direct administrative control. So again, communications for purposes of payment can be done without express patient consent, but that's a very limited exception. Okay, let's see if we can fly through this. This will be a fairly familiar concept, I think, the idea of a qualified service organization. That's another exception. A qualified service organization is a lot like a business associate under HIPAA law. These are entities that are providing services to the Part 2 program, and there are a variety of services: legal, accounting, population health management. In those situations, you don't need to have patient consent to have disclosure to that QSO, but there does need to be a QSO agreement, and there are certain requirements, fewer requirements in Part 2 actually for the contents of that agreement as compared to the BA, the Business Associate Agreement, BAA, or now the Business Associate Contract under HIPAA, but there are some requirements. And importantly, though, that's only a two-way relationship. The QSO and the Part 2 program can release information back and forth, and an HIO can be a QSO, but that does not give the HIE permission to then share it with other members of the HIO. Okay, so it's a limited two-way directional sharing of information between the QSO and the Part 2 program. Okay, so this is some more definitions on QSOs, and again, the fact that SAMHSA has permitted population health services to be within the scope of services that a QSO may provide, but not care coordination or medical management, which again, it's deemed that to include a treatment component that it's not going to permit without patient consent. I'm going to really go quick here. I'm going to flip right over these. These are more exceptions, but they're more unusual. Crimes on Part 2 programs or against Part 2 program personnel. Those are exceptions to Part 2 consent requirement. Reports of suspected child abuse and neglect, another exception. Research exceptions with limitations. Again, you have to de-identify and aggregate the data. Audit and evaluation is another exception with, again, multiple qualifiers. So the big takeaway that I already kind of gave away was that with Part 2, there is no TPO, treatment, payment, or operations exception akin to the exception we have in HIPAA. So whereas with HIPAA records, you oftentimes can have integrated care with HIPAA with no issue with respect to patient consent because of the treatment, payment, operations exception, you don't have a similar ability easily to share information among treatment providers with Part 2 records. You need to have consent in the vast majority unless you're going to satisfy the bona fide medical emergency exception. Or the example of the internal communication, for example, where you have a supervisor within the Part 2 program and a substance use counselor, for example. Those are very narrow treatment-like exceptions. Okay. And then just to highlight, because given the audience, I think the interest here to know that SAMHSA has taken steps to make it clear that it does believe, and it's been doing this, I think 2010 was the first guidance document, an FAQ, to say absolutely, they say it, now it is more complicated, but conceptually, Part 2 records can be put into electronic health records and other health information sharing technology. They issued express FAQs, and now they've done various amendments trying to make it clear that, yes, we're not trying to exclude these records. In practice, though, many, many times providers just have not figured out how to get either to get the EHRs to work, to have the data segmentation, to make sure you have the right consent, or to track the consents for minors or whatnot. So many times you don't have the sharing of information of substance use records, but it's not because the law prohibits it. It's much more of an operational bar at this point, as well as, I think, a lack of understanding of what the law permits. But there are FAQs that specifically talk about the fact that you can have these Part 2 records within EHRs. And that, as I said earlier, an HIO can be a qualified service organization for that bi-directional communication with the Part 2 program. This is more about some of the guidance and some of the progress that SAMHSA has made over the years. It's expressly acknowledged that we have developing integrated care models, and we want patients with substance use disorders to avail themselves of that coordinated care. They want those records to be available for coordinated care. And so they're trying to clarify, and it's still a work in progress because there still remains a lot of confusion, but as a policy matter, that is something that SAMHSA has embraced, the fact that Part 2 records should be able to be exchanged in integrated care models. And this just gives, again, a little bit more about what SAMHSA has said to date, and the ability to have a single consent form, for example, that authorizes disclosure to an HIO in the same document that then also permits the HIO to disclose to other HIO members using the general designations where permitted and other elements of the consent that we went through a few slides ago. To date, SAMHSA has not answered calls. There have been calls, including legislation pending last fall, legislation that continues to be pending right now, to align Part 2 and HIPAA and to say there should be a treatment payment operations exception to the confidentiality restrictions in Part 2 for that is the same as, comparable to, the HIPAA TPO. To just make this simpler, mean all these records can be exchanged for the same purposes because it's in service of coordinated care and informed care. SAMHSA has not yet done that. Legislation almost passed last fall, but it in the end didn't. There is more legislation pending now. But they've said that they're trying to balance this idea of we want to encourage integrated care, we want to encourage coordinated care, but we also want to protect these records. And there has been a lobby that worries about the risk to patients that they may not seek treatment because of fear of discrimination and stigma. Whether that would actually happen or not, if it actually is what if they mentally believe that's going to happen and they don't go get care, it's certainly not what we want with the opioid epidemic, to have reduced access to care. Others say you can't get good care if you don't have access to these records because you can't treat the whole person. And you need to have all this information available so that you can know what you're facing as a medical provider and best treat the patient. So it's an ongoing debate. So as I said, there are pending bills. The scuttlebutt is that there will be a notice of proposed rulemaking soon from SAMHSA that will, in fact, do what the legislation has not yet done, which is create a treatment payment operations exception to the confidentiality restrictions of Part 2. And here, this slide again acknowledges the wrestling debate, whether or not you do worry about the stigma or whether or not you need to do this for better care. You have to have these records available to treatment providers to better coordinate care and provide better care. Okay, whoops. General principle, you've got Part 2, you've got HIPAA, 2 federal laws. Just want a little baseline about preemption issues. Many programs are going to be bound by HIPAA. They're going to be covered entities under HIPAA, as well as then be a Part 2 program. And they have to comply with both laws. And so you have to comply with the more stringent law. And so in most cases, that's going to be Part 2. Then a similar principle applies with respect to state laws. HIPAA is a baseline. Part 2 is a baseline. If you are covered by those laws, no state can be less protective than those laws. If you're a Part 2 program in the state, there's no state can go and be less protective than Part 2 provisions, but states can be more stringent, more protective. And so that gets us to a quick overview of Michigan laws. And I'm really going to go fast because I want this discussion. Basically, I think I'm the one who's I'm not a Michigan person. So you guys probably sleep, breathe. Many people in this room are from Michigan. Not everyone, but I've heard a lot of Michigan people today. So just know generally, as a general principle, states can be more protective. And then in Michigan has taken efforts to be protective of health while also encouraging the better sharing of health. And so many laws in Michigan permit the sharing for treatment, and at the very least with consent. And so in many instances, Michigan law already permits a great sharing of substance use and mental health records, at least with consent, and in many instances without consent, just for purposes of treatment and payment and operations. In fact, it passed a law in 2014 where it required the state to develop a standard release form that would apply to mental health and substance use disorder records. Okay, so there's a specific law that requires that form, and it has been developed. Providers do not have to use the form, but they must honor it if it's presented to them. I'm not sure what the uptake has been. I think a lot of providers continue to be nervous. They have their internal legal counsel. They worked hard at developing their own forms, and so they're not really ready to give up. They want to keep using their own forms. But if they're presented with one, they need to honor that as being a legally compliant consent form. A lot of this is about mental health, and this is about some Michigan mental health provisions. There was, again, a Michigan law that specifically, these mental health records or mental health services, it's an undefined term in the statute, they have to be kept confidential. There has been some broadening of that, of what can you do with these records, some permissibility to exchange them, expressly naming HIPAA, but importantly using some different language. So I'm going to get to a slide to it in just a minute to show you. But the idea was, first you've got mental health records or mental health services records are confidential. They don't define mental health services, but the definition of recipient in the Michigan law excludes when the services are for substance use, unless it's being done, I want to get the language right, in conjunction. Okay, so unless the mental health services are being done in conjunction with substance use disorder services, the provisions didn't apply to substance use. Okay, so that was sort of the baseline Michigan law. And then when Michigan amended the law in 2016, it specifically permitted the disclosure of mental health services records without patient consent. And the quote is, as necessary for treatment, coordination of care, or payment for the delivery of mental health services, okay, in accordance with the HIPAA. It specifically names HIPAA. And remember, we've been saying the TPO, the Treatment Payment Operations Exception. That's the language in HIPAA. But what the Michigan law said is treatment, coordination of care, or payment. Coordination of care instead of operations. And it's not clear what this law is protecting. Should everything that HIPAA says about operations be imported into Michigan law, or is coordination of care its own separate term? And there are some important differences in the law based on this word choice. And so there's it's a curious amendment that had the intention to bring Michigan law with respect to mental health services records in line with HIPAA, but there have been some implementation challenges with respect to whether that's true based on the word choice in the legislation. And so, as I said, remember, it says in the definition of treatment that it includes substance use disorder records. But if we remember from a few slides ago, the definition of recipient excluded substance use treatment unless it was done in conjunction with. So that's one ambiguity that needs to be clarified in Michigan law. The other issue is with respect to, again, that the choice of coordination of care instead of the word operations, which is the HIPAA language. And it makes a difference because coordination of care is language used in the definition of treatment as well as in the definition of operations in HIPAA. And the treatment exception in HIPAA doesn't require a treatment provider relationship. It also doesn't, it's not bound by HIPAA's minimum necessary requirement. But the HIPAA operations exception, which also uses coordination in its definition, is bound by the minimum necessary and does have an existing treatment provider relationship requirement. So because Michigan uses a coordination and not operations, it's not clear which of the governing law from HIPAA is being imported into Michigan law. So there's been an effort in Michigan to clarify and bring Michigan law in line with federal HIPAA law, but there are some questions that need to be clarified. Also, the Michigan law says as necessary, which is not a requirement in HIPAA, so another issue. And another thing that was not addressed is psychotherapy notes. I don't know if you'll recall in the HIPAA context, psychotherapy notes are accepted from the treatment operations, the TPO exception. Records of treatment can be exchanged without patient authorization, but not psychotherapy notes. Those do require patient consent. Is that being imported into Michigan law? Are psychotherapy notes still treated differently? You would think so. It's a baseline, right? How can it be less protective? But it would be helpful to have that clarified in Michigan law. Okay. Let's see. The other thing is just that Michigan does have some laws specifically on substance use disorder services. So this gives you the citation. There are a couple of exceptions. They really do seem to parallel Part 2 in many respects. There's similar language. There's talk about a medical emergency exception. But I do note in the slide some variations, some slight questions where it's not clear that they are fully in line with Part 2. And so something I encourage the state to look at. Another example is that the Michigan law seems to require written revocation, whereas Part 2 does not. So I would argue that that's preempted as a less restrictive protection of confidentiality. There are a few things in here about minors. I, again, want to get to our panel, so I'm going to leave that to you to read later if it interests you, but just know that there are specific state provisions on substance use treatment records. And I do have a summary of how they're similar to Part 2, how Michigan law on substance use treatment records are similar. So I said it requires a written consent. There's no generally applicable treatment exception. There is something similar to the bona fide medical emergency exception. It also does not define medical personnel. But then, as I said, there are some differences with respect to Part 2, like the written revocation requirement. There is a broader definition of program, arguably. It also seems to go beyond just the treatment records and have broader coverage of what records are included. And so, again, clarification from the state as to its scope and how much it aligns with Part 2, or is the state deliberately choosing to have more requirements or not? Okay, so I'm going to stop there. There are a few more slides that just talk about a few other things in Michigan law, like program regulations that add some other requirements, some professional licensing provisions in Michigan that impact the confidentiality of these records. But the main points I've made, it's the issues with respect to what does the HIPAA, the revisions of Michigan law to try to align with HIPAA, and also just the existence of substance use specific Michigan laws and how they are similar to and in some ways different from federal Part 2 law. And so the final slides really just sort of give an overview of some of the takeaways from the analysis we did, talking about the operational challenges, the legal complexities, the confusion, and it's really a good time for Michigan and every state to make sure that the variations between federal law and state law are deliberate. It's one thing if a state's making a conscious decision to have variations because it wants to be more protective. It can't be less protective than federal, but it can be more protective. But if the variations are just because they've evolved, they're legacies of a prior system, they're undefined terms, there's no real need for them to be different, that should be rectified to kind of clarify for providers so there's less confusion and hopefully less than resistance out of ignorance rather than because the laws really do prevent the sharing of information. So with that, I'm going to sit down and ask for the much more important work to be done by this committee, this panel, to talk about the different issues that we have. Maybe I'll stand. Okay, so first I want to turn it over to the panel. Their bios are in the packet. I don't want to waste time reading them because I want you to be able to hear from them. But did Corey have to leave already? Oh, shucks. See, there's no time. I knew we had to leave at 2, but it just gives me, it says 39. I don't know what 39 means.
It's 2:17.
It is. Oh, that's a shame because I would have loved for you to hear from Corey. So it was going to say, in your respective roles as attorney, policy advocate, and provider, and he was the provider, what would you say are the key challenges to sharing behavioral health information? And so I'll turn to Pamela and ask you to share with me some of your thoughts on that.
Sure. Thanks, Tara. And in case you haven't had a chance to read my bio, I run the Association for Behavioral Health and Wellness. We represent health plans that serve about 200 million covered lives. I'm based in DC, focused on federal legislation and policy. And one thing that's not in the bio is that we run a coalition called the Partnership to Amend 42 CFR Part 2, looking to align Part 2 with HIPAA for the purposes of treatment, payment, and healthcare operations. It's about 50 national associations that are members of that group. We've been told by Deputy Secretary Hargan that he loves the name of the coalition because it's one of the only ones that the name says what it wants to do. So the communications people, of course, hate the name because it's very boring and dry, but it does in it say what we want to do. But to answer Tara's question, I think for what we've seen in the partnership and for our member companies, some of the challenges are, first of all, understanding when Part 2 applies. Just in a meeting with the Assistant Secretary at the head of SAMHSA last week, we were talking about one of the groups was hospitals that work with some ACOs, and they were talking about reasons why some of their information isn't shared, and she said that's not a Part 2 violation, but clearly these big name companies like Johns Hopkins think that it is. And so for us, just understanding Part 2, it's so complicated to know when you actually are a Part 2 provider, and providers tend to err on the side of being cautious, and so oftentimes they will think they're a Part 2 provider and won't share information just to make sure they're not in violation. So that's a challenge. Not being able to get the consent, maybe you didn't get it all up front, or you didn't ask for any consent up front because you weren't thinking about it, then you have to go back and find the individual to get the consent. If you're dealing with a Medicaid population, they may have moved by the time you got them. They may not even have a cell phone or a computer to be able to get in touch, so that's a problem. You know, sometimes you have to get multiple consents because maybe you got the consent, but they said you can only disclose it to this individual, and you want to try to disclose it to someone else, so you've got to go back. And then I think I'll maybe speak for Dr. Waller and say that also from the provider perspective, not having all of the information. And you know, I think what that looks like is you've got a record. There's nothing that says this record is missing the substance use disorder information, right? It's just not there. So many providers aren't looking at it thinking, okay, but keep in mind, I don't have the substance use disorder information. I think your natural way is to think, okay, this person does not have an addiction. And then, you know, one of the things Tara mentioned is that under the current regs, the person has the ability to say, I want this disclosed, but not that. So you could say, I don't mind them knowing that I had an addiction 10 years ago to alcohol, and that's been treated, but I don't want them to know that a week ago I was treated for an opioid use disorder. So again, if you're a provider, you see the alcohol, you think, okay, I've got everything, the information was disclosed. Again, you're not thinking, oh, but the patient had the opportunity to decide what they wanted disclosed and what they didn't want disclosed. So I think those are some of the challenges that we see.
Thank you. Adam, how about from your perspective as an attorney?
Yeah, absolutely. Hi, everyone. Just a brief introduction. So I'm Adam Hepworth. I'm a healthcare regulatory attorney with Foley and Lardner, and I often represent hospitals, physician groups, large health systems, sometimes county public health departments and county hospitals. And so I sort of come to this with the perspective from those sorts of clients and the issues I see representing them. I would echo everything that's been said, but one thing that I think is particularly significant that sometimes gets overlooked in the Part 2 context is how difficult the consent process actually is. And in particular, what I've seen over the last few years are a lot of clients trying to do more integrated healthcare and address sometimes the social determinants of health, which often means going beyond the traditional medical context of disclosure from doctor to doctor or doctor to hospital, and maybe bringing in housing or food security issues or education or justice. And all of these entities that are outside of the normal healthcare context, under Part 2, you absolutely need a consent to share information with them, but it's much worse than that. You basically can't do it if you have a large program at scale and need flexibility, because if they don't have a treating provider relationship, they have to be individually named in the consent form. And that's where I've seen huge struggles from really innovative programs trying to sort of do cutting edge integration, and just, even when the patient wants the information to be shared and would like to be part of the program and would benefit from these services, if the consent forms or requirements are too onerous and you can't get a valid consent, you're sort of stuck. And the only thing to do at that point is either segment out the substance use disorder information, if you're a Part 2 program, or we mentioned earlier you could go and get consent forms that name people by individual by individual, but that's just not practical if you're running a large program. And this was something that SAMHSA addressed in 2017 in the latest final rule, when they tried to relax those consent requirements by adding the few areas where you can have a general designation, like was just mentioned in the presentation. But that's all good and well if you're disclosing to someone with a treating provider relationship, and it becomes much more murky if you're trying to do something that might be in a gray area or even clearly outside of that context.
Thank you. I just want to, I can't speak for Dr. Waller, but I know that one of the things he planned to discuss is that he thinks one of the most serious and pressing problems in this area is the overly restrictive interpretation of these laws. That generally, I sort of alluded to it in my comments, that not only is there a lack of understanding, and also that it is complex and not always clear and sometimes murky, I think given the murkiness, given the lack of knowledge, it leads to risk-averse attorneys in various facilities saying, we're just not going to take a chance. We're not going to release these records. We're not going to put them out there because we don't want to take the chance. And so he finds as a fairly common problem is that there is this overly restrictive interpretation of Part 2 and other laws governing the privacy of these records at the state level, for example.
And I think sometimes people even add mental health to that list, even though it's not covered by Part 2. They just kind of say, okay, behavioral health, let's not deal with it.
Yeah, I think the terminology, it's something that comes up. Even I'm teaching a class this summer on mental health parity, but mental health parity is really a misnomer because mental health parity actually applies to substance use records now. Why are we still calling it mental health? So not everyone, I guess the more common terminology is mental health and substance use are within the umbrella of behavioral health. Part 2 is not about mental health. Part 2 is about substance use. But as you just said, that sometimes people are interpreting it as bringing in mental health and saying, okay, let's just protect both. All of it, and there's a restriction. And you see, Michigan took steps to say, no, mental health records, you can release them. We're going to have a similar TPO exception, although, again, I'm not really sure what happened and how you could have just copied right from HIPAA. It would have been nice and clean, but they changed the language a little bit that introduced some ambiguity and confusion. But at least they were trying. The goal was pretty clear. They wanted to go in the direction of HIPAA, and certainly did not go in the direction of making mental health records as protected as substance use records in Part 2.
You know, Tara, if you're talking about parity, here's one area, right, where there isn't parity because the substance use disorder records are treated differently from mental health and treated differently from the medical side. And as health plans who are getting criticized all the time for not implementing parity to its fullest, you know, and then here's an area where there isn't parity. So there are advocates who want parity for everything else, right, in the treatment and the way the co-payments, et cetera, but not in terms of the way the records are treated. So maybe you can add that to your class.
Yes, maybe we'll have to. Adam, I think you mentioned at one point, even folks who are trying to be innovative. So that brings me to a question. I'd love to hear what you have heard. What kinds of ideas are out there that are gaining traction or you think should gain traction to try to address this issue? Are there states doing it better than others? Are there private entities? You know, what's working and what's the path forward, you think?
Yeah, I mean, I think a lot of providers are trying to address this problem. So one area where I have some experience that's kind of, I think, a unique situation are certain Medicaid demonstration projects in California. And as part of California's Medicaid 1115 waiver, they have something called the Whole Person Care Program. And this is basically designed to integrate care and treat the whole person for some of the most vulnerable Medicaid beneficiaries. So it targets individuals who have multiple chronic conditions or have experienced homelessness or other increased ED visits, other sort of risk factors. And part of the whole philosophy behind this program was to try to connect up healthcare providers and social services providers who interact with these individuals to do a better job. And this was not a small program, by the way. It's like a $3.1 billion program. Half of that's federal money, half is local. And what everyone found who I worked with or talked to when they were implementing this, which is mostly, it was led by counties, but it was required to have all sorts of partnerships. So it would usually be the county, the public health department, the managed care plan, key social service providers, and of course healthcare providers. And what they all found is the real huge threshold challenge is how to share health information. I mean, if you want to do all of these amazing things, you can't do it if you're all operating in silos. And so in California, one of the things that the state did to try to make this easier was actually pass state legislation that for these whole person care programs just exempted them from all the state healthcare privacy laws. So that was a huge deal. Immediately now you're left with HIPAA in Part 2, and it's a little bit of a easier playing field to not have to also be dealing with California's general information law, its own mental health law, its own substance use information law, its HIV law, all of those other laws that apply. But of course, as we've just been talking about, Part 2 is a huge barrier, and the state can't really do anything on its own to relax that. And so I've seen a lot of people trying innovative solutions. I think it's always a struggle. One area that there was a lot of interest in was how far can we take the general designations for past, current, and future treating providers. And I think this was mentioned briefly in your remarks, but SAMHSA really hasn't been willing to give a lot of clarification about what that means. I actually have the line here. In the rulemaking, there was so much interest in this that people asked all of these questions, would this count, would this count? And SAMHSA just said it respectfully declines to provide more specificity because the arrangements between treating providers and other entities evolve too rapidly to be comprehensively addressed in regulations. I mean, on the one hand, you've got to be sympathetic because it's probably completely true. But on the other hand, the providers are left saying, well, then what do we do? How do we know if we fit into this category or not? And to the point that's just been raised, if you're risk averse at all, which large health systems tend to be, then the answer is, well, we can't do this. But on the other hand, SAMHSA also said in that same preamble, the definition of treating provider relationship is sufficiently broad to cover the necessary components of a patient's care team. So one thing, some of these whole person care pilots or other systems I've worked with have narrowed in on that language and said, well, we're going to push this as far as we can, and anyone who can really, make a plausible argument that they're part of the patient's care team, we're going to do it so that we can get a valid consent that allows us to share with them, which we think is in the best interest and is also in the patient's interest. And that's sort of one strategy I've seen, which lives a little bit in the regulatory gray zone, but it's certainly defensible. And I mean, another thing I just point out about that, which I think is interesting sort of from a policy and philosophical level, is we've been having these discussions about, what's the purpose of Part 2. Its origins are rooted in this concern about stigma, which is a policy concern about how too widespread sharing of this information will hurt individuals. But I think there are other policy concerns that have sort of been left out of the conversation that are equally patient-focused, and not just the ones we've heard about appropriate care, but I often come back to the idea of patient autonomy and patient choice. And one of the weird things about SAMHSA is that the consent requirements are so burdensome that they're often the challenge, which to me is kind of bizarre, because you have situations when patients really, really want to share the information and they still can't because it's operationally impossible, because you're not allowed to have a general designation that's broader than treating providers. And so that's one area where I'd like to see sort of more of a robust, holistic policy discussion that incorporates that patient advocacy view about, how do you ensure that when the patient wants to make this choice, they're able to. Sorry, just one more aside on that issue. I think it's pretty interesting. You started out your presentation mentioning how the statute is not super specific in most areas and it's largely implemented through regulation. Well, one of the areas where the statute actually says absolutely nothing is how the consent process works. It just says, the regulatory agency will develop regulations to do this, which means this is an area where if SAMHSA wanted to, basically overnight, they could make the consent much more flexible. And it's always been a little bit of a mystery why the consent has to be so challenging and so difficult when that itself is not required by statute in any way whatsoever.
Pamela? Do you have any thoughts on whether states or entities that are doing this well, or things that we should try to replicate in other states to improve the sharing?
Not really. I think we just need to change the federal law, to be honest. I know that our members just have a difficult time, even when they've seen things where disclosure would benefit the patient, and they've called me up and said, I don't know what to do because I know I'd be violating Part 2 if I disclose this information, but I honestly believe this is the best thing to do for the patient, and obviously in a very specific situation. So I haven't seen good workarounds.
I've raised, and I'd love to explore the question of the balance between privacy interests and the risk of discrimination and deterring folks from treatment versus the idea that you want to have all the information available so that you can treat the whole patient and not be in the dark as a treatment provider, not knowing. I'd love to talk about that, but I also want to talk about the stuff that I know nothing about. So I'm selfish, right? I want to learn from you guys. What about the technology? Are we at a place where we actually can do the sharing of information? Little I've heard about this, given the consent requirement, maybe this goes to your point, get rid of the consent requirement and you won't have this issue, but data segmentation, for example, that the technology is just not there, that you have really small fields in the medical records because you don't have a lot of narrative text, but in behavioral health records, it's all narrative. So how do you get the systems to work together? I don't know if you're the right folks to ask, but can we even do this? If we change the law and we didn't have, we were able to do the sharing, are we there technologically? Can we do the sharing in EHRs now?
We do have an EHR vendor as part of the partnership. And when we met with Dr. McCants-Katz last week, the head of SAMHSA, that issue did come up. And what they basically said is, that we're not really there yet, that they don't kind of have the ability to segment off the substance use disorder record and lift the door, so to speak, when the consent is there. There is the consent to share that was developed by SAMHSA a few years ago, and at least, again, what I've heard is that nobody to very little people are using it, that it's very expensive to undertake and implement the consent to share. So at least what I've heard is that we aren't there yet.
Okay, Adam?
I've basically heard the same thing. It's a huge difficulty. And one other place is even health systems I've seen that may be able to effectuate a consent and share substance use information when they have a consent. Often that doesn't mean they can do any sort of segmentation within that category. So then when you go to the next level of giving patients the option of saying, oh, I want to share this substance use information but not this, I don't think I've ever worked with anyone who could actually go that far and do that effectively, because it's just, then you're beyond even a general category or general tagging or provider type, and you're really making a nuanced, inquiry into the data and where it can go. And that's just extremely, extremely difficult.
The other thing is that behavioral health providers, as I think we all know, are behind in terms of even implementing electronic health record, or frankly, using a computer. And we were asked the question last week, well, what about paper records? What do you do about that? And there was kind of like silence in the room. But you're talking about implementing the segmentation, but oftentimes we're not even talking about an electronic health record when it comes to substance use disorder records.
So what do we think the best policy approach is? Is it just align Part 2 with HIPAA and that's it? Or do we need to do, and what can we do to address the concerns about stigma and discrimination and potentially deterring folks from seeking treatment? I know, for example, one bill has anti-discrimination language in it, and to try to address it from that perspective and prohibit any information that comes from Part 2 records from being used against a person for employment decisions, things like that. Will they be effective? Will that address the concerns? Put on the hat someone who disagrees with you, and let's, because I always like to have a well-balanced panel. What do we think about those concerns and how we can accommodate those and respond to those while still moving forward and getting all the information shared for providers?
Well, I think the biggest thing, first of all, to think about is that in everything we're asking for, we are not saying get rid of the Part 2 protections. That is not what we are advocating for. We're advocating for alignment with HIPAA for treatment, payment, and healthcare operations, but we're not looking to get rid of current protections. And in fact, we did in the House bill that passed last year by a vote of 357 to 57, which is quite a good vote for legislation. We've added some protections in there. Some of the things we did was align with HIPAA for violations, and so that is quite extensive. The current violations are somewhere between $50 and $500, and actually when we had a study done, they tried to look back to where the violation or the fines could be implemented. And the law that the original Part 2 law refers back to doesn't even exist anymore. So we aren't even aware of anybody who's been charged and actually received a fine for violation of Part 2. So with the bill that we passed, we aligned with HIPAA, which we know HIPAA violations are and fines are implemented. Providers and health plans pay much more attention to HIPAA than they do to Part 2 just because it's so much more comprehensive. So we've added larger fines, which we think will keep people away from unlawful disclosure. We added also breach notifications based on the HITECH Act, which didn't exist before. So we kept existing and added to. And I think that should address most of the concerns. Look, if a provider wants to release the information, they could do it now without a consent. They might do it if the changes are made. There's nothing you can do other than fines from trying to stop somebody from the breach. And we increase those.
Okay.
I'll let Adam talk.
Adam?
I think that was a great point about enforcement. It's always sort of an interesting fact that Part 2 causes so much chaos and confusion and stops so many things from happening when there's basically no track record of it being enforced, but everyone's afraid that it will be. And of course, and people want to do the right thing and they want to follow the law, and that's a powerful force as well. So I think it's, if you could bring it into a regime that was more predictable and more stable, that would certainly be helpful. And I would also agree, I don't think that the clients I worked with necessarily would, I mean, some of them might be happy if Part 2 just disappeared overnight, but I don't think all of them would, and I think more targeted changes would be appreciated. And going back to the examples I've discussed, also if just the consent process were more like the HIPAA consent process, that would really make things a lot simpler.
You know, the other thing is that many of us argue that actually the Part 2 requirements are more stigmatizing because you don't have that consent for anything else, including mental health, including HIV. So you have a substance use disorder and you're faced with this consent form, quite long and lengthy, as Tara has described very well, and you think, well, wait, I don't do this for my depression, or I don't do this for my cancer diagnosis. You know, what's wrong with me or what's wrong with having an addiction that I have to do all of this now for substance use disorders? And second, this only applies, as Tara said, to providers that hold themselves out as substance use disorder providers and receive federal funds. So if you're going to see a doctor that doesn't receive any federal funds but is a substance use disorder provider, they don't comply with Part 2. They comply with HIPAA. So in some ways, this is a substandard care because my doctor that doesn't receive federal funds has my whole record and is treating me as a whole person. But the doctor that does receive federal funds isn't getting the whole information.
Well, that's only if the doctor doesn't have like a CDS certification from DEA or isn't a data waiver, right? So it would have to be someone who does substance use treatment without prescribing medications for substance use treatment. Because if you have the DEA waiver or if you have the CDS, that's qualifies as federally assisted. So they would be bound by Part 2.
Right, but there are providers that are not federally assisted in some way where they're still treating substance use disorders, but not with MAT or something like that.
Okay. I want to open it up to the floor for questions. I just want to give you both an opportunity. Is there something you wanted to ask each other or me or raise that hasn't been raised before we go out to the floor, to the audience?
If there's time and people are interested, I can kind of give an update of where we are in DC on these issues, but I think it's more important to go to the audience first.
Okay, so we'll take a couple questions, then hopefully get that back.
Hi, good afternoon. My name is Diana Bunchu. I'm from Oakland Community Health Network, which is a prepaid inpatient health plan in CMH here in the state of Michigan. One of the things that we spend a lot of time talking about Part 2 of 42 CFR, but what we didn't spend any time talking about is how in Michigan we don't share any behavioral health information that would even fall outside of that Part 2. And here we are ready to stand, and in fact we are going to be one of the first organizations that's at least going to start with ADTs for non-SUD people. But how do we get organizations in the state of Michigan to catch on and to also do it? Because, we talk a lot about integrated healthcare, but how do you do integrated healthcare if we're not integrating at the person level? And along with that, consent. I think really talking about standardized consent and consent that can be across the organizations, I think would be really great. So then that way we know, yes, we can see that checkbox, yes, we can send out that data, and it seems to be we're not really there. So I just wanted to point out the other thing is we actually are very advanced in Oakland County when it comes to EHRs, and our providers and us are once again, it's not a paper organization, so that's not withholding us back. I think there's a lot of misconception also about the Michigan Mental Health Code.
You want to respond?
I could just talk a little bit about my experience in terms of pushing some of these efforts along. I think sometimes it is hard because it's such a heavy lift and it's such an effort. And so, just to go back to the Medicaid demonstration project I was mentioning earlier, that was really helpful in these counties in California to start getting things integrated. And there's, one reason obviously was there was a huge carrot. There was tons and tons of money that was flowing in for building out infrastructure to accomplish the goals of the project. And so, if you can get Medicaid financing or some other payment stream that's going to help you build out these systems, that always helps. But it also just sort of created a space for entities that may have already been interested in this to get together, to communicate with each other, to develop sort of a joint plan, and to be put on a timetable of how they had to do this. So really, any sort of outside energy that you can push into the system to try to move things along, I think can be quite helpful.
Pam, did you want to
I don't
respond?
have a
No?
comment on it.
Thank you. Any other questions? Yes. Is there a microphone?
Oh.
Oh, you have one already.
I
I'm
got
sorry,
one.
you have
Tim Pletcher. So is there any advantage, because we've talked about it a couple different times, for Health Information Network to basically execute a qualified service organization with all the Part 2 facilities separately? Can you think of any reason or justification why that would be helpful to us as the HIE entity for connecting all the dots?
Do you want to jump on that?
I mean, I don't know. I think it's a hard question to answer in the abstract. You know, the question is sort of what are the goals? What are you trying to do with the information? Are you trying to do something that the qualified service organization structure will allow you to accomplish that you couldn't accomplish with some other structure? I mean, I think it requires sort of a holistic look at who's involved, what information do they need, and what are they doing with it before you get to the stage of which agreement should I put in place or how should I actually accomplish this?
Yeah, I think we would need to know more to give that advice.
Yeah, I would have the same reaction. Did you want to follow up or no? Okay.
Yeah, it would essentially allow us to do kind of a better job of receiving information, processing it. In particular, we have something called the Active Care Relationship Service. So we would be able to work from a population health perspective of all of these substance abuse providers are connected to these patients and sort of manage that deeply, if you will, but from the context of the actual Part 2 facility, so that when we had physical health information, it was a lot easier to move it to them because we kind of know more about what's going on in their environment.
But just being a QSO is only going to let you have the bi-directional, right? So if you go and you have a relationship with each provider, you can exchange information from you to that provider and back and forth with respect to population health. That is within the permissible functions of a QSO, but you can't share it. Whatever you learn from aggregating the data, you can't share it with the other providers until you then have consents that permit that sharing. So I'm not sure it's going to
Think of it more as a one-way mirror. We want to make it easier for the information from the outside world to be able to flow to that. Not the Part 2 information, all the other information a lot easier. But we actually need deeper insight into who the Part 2 facility is really servicing. And that we believe that provides additional coverage to us by doing that on behalf of the actual Part 2 facility.
So, I want to make sure I get your question. You're saying, is there a reason not to? Because you can think of lots of reasons to do it. You're wondering if there's a reason not to.
Yeah, or is it a false protection? You know.
Yeah, I mean, I don't know if there's any reason other than money and time, to know whether it's going to get you what you want to get. I don't know if anyone else has thoughts on that.
Well, and in the to-be-issued notice of proposed rulemaking, at least we are hoping that there's more flexibility with the QSOs, and if that happens, you may have a greater reason to do it. We don't know that yet, but stay tuned.
Yeah, the scuttlebutt is this summer? Is that later this summer? Is that what? No?
60 to 90 days is what we were told last week, but, those are always moving deadlines because there are many people who make that decision.
Okay. Yes.
Hi. Carol Robinson, Cedar Birch Group. I had two questions. One you might have started to answer, which was, sure, I'd like an update from Washington, D.C. And then the second was, do you know an estimate of how many substance abuse treatment facilities are not receiving some sort of federal funding? Because when you really dug into the details of that, that was a lot broader than I had been aware of how the federal funding would be defined. Mm-hmm. So I'm just curious about like what percentage of facilities don't take any federal funds that would count in that?
Yeah, I unfortunately don't have numbers. I do think Dr. Waller I remember in a phone call, he made a comment that something was eye-opening to me. I was aware of the folks, providers wanting more information, and some folks really worrying about deterring treatment and stigma. But then what he said was, actually, you've got the folks who are worried about stigma, also some providers, substance use treatment facilities that are not the good eggs. And they're not that all of them are, no, I'm not saying that, but there are some. And that they actually are resisting this because of a fear of quality measures being done, and that they would be found to not be doing good care, and they want to discourage that. And I was like, oh my gosh, I didn't know about that. That's a horrible reason to oppose this type of sharing of information. I don't know if those facilities, I would think the federal government probably is going to vet who they're spending money on. There may be privately funded entities, and maybe no one in them has a DEA certification, and maybe there are all these ways that you don't qualify. I would be completely speculating. I don't know if either of you knows?
I have not seen those numbers, but you do, at least in terms of the Data 2000 waivered providers, there are a lot of facilities that do not provide MAT for a variety of reasons. So at least if you were thinking that, because I think that was one of the more newer nuggets, there are a lot of facilities that don't, but I haven't seen any numbers.
Yeah,
And I don't know if they also don't receive federal funds.
I haven't seen numbers either. Most of the providers I work with, they're always federally assisted because they either take Medicare or Medicaid, and that's sort of the end of it. Yeah.
Right. Sorry, but I do think you can provide the DC update if you don't mind.
So the update, and Tara indicated, there are bills that have been reintroduced this Congress, and if you're so inclined to get in touch with your member of Congress to encourage them to support them, we'd be appreciative. HR 2062 in the House, Congressman Blumenauer and Mullen are the two co-sponsors, and it's called, for short, the OPS Act, the Opioid Prevention and Patient Safety Act, and then in the Senate it's S1012, and it's the Protecting Jessica Grubb's Legacy Act. You know, Jessica Grubb was most recently from Michigan before she passed away. They're identical bills that would, they have all the protections I mentioned earlier, but they also would align for purposes of treatment, payment, and healthcare operations. The hope right now is that there's a broad bill on transparency that may move through the Senate this summer, and we would like to see the Protecting Jessica Grubb's Act, because it's the Senate, added to that bill. So co-sponsors right now in the Senate especially are important. On the regulatory side, and we're pursuing both because the regulators, we don't believe, have the legal authority to get rid of the consent, and we would like to get rid of the consent for treatment, payment, and healthcare operations, so we still need the legislation to do that. And then the regulations we're hoping will move more towards treatment, payment, and healthcare operations once you have the consent, and just make things easier. The notice of proposed rulemaking is at the Office of Management and Budget for review, and once the OMB decides to release the rule, which is what we've heard may be 60 or 90 days, then there will be a comment period. I encourage you to comment. We've been told by both HHS and SAMHSA that comments will be very important. I encourage you to comment only if you agree with what I've said so far today. Just kidding, kind of. And if you know consumers that are willing to comment, that will be really important. But you'll have a comment opportunity, I don't know for how long, and then that rule will be finalized. Some of the things may have to wait. There will also be a HIPAA notice of proposed rulemaking at some time, and some of the issues may have to wait for that. I don't know, but we've kind of been noticed that maybe some things will have to wait for HIPAA.
Okay. Do we have time for another question? I'm trying to look for someone who can tell me. Okay, you have the mic. You've
Yes,
got the power.
Bharat Gandhi, MiHIN. Can we turn to the question of enforcement? Can you speak a little bit to what kinds of enforcement you've seen in the Part 2 area? What are the penalties, and who's effectively the enforcement agency?
I think you sort of mentioned before that there really isn't any, right? That you haven't seen any?
Yeah, we don't tend to see much enforcement of Part 2, but I mean, it is a criminal law, and there are fines associated with it, and the regulations, explain how that works. There's no private right of action of Part 2, which is different from some state laws. So often state health information laws have a way for patients who feel aggrieved to bring a complaint, which can lead to huge class actions or other significant enforcement actions. Part 2 doesn't have that mechanism. And then, as was mentioned earlier, in the HIPAA world, I think we're all aware OCR is very active, doing audits, doing CMPs, doing corrective action plans. We really don't see that sort of activity in the Part 2 world.
So why do you think people are scared? Why do you think that they're risk averse, and why do you think there's the overly restrictive interpretations that Dr. Waller is concerned about?
It's still the law. I mean, I think if people want to follow the law, the potential for penalties is there. I mean, it could change any day. You could have some enterprising, I think U.S. attorneys can enforce it. You could have some enterprising U.S. attorney decide that, they think things are going badly because this information is being shared and they want to go after someone. And I think just the health information and health privacy world in general it's very highly regulated. There's enforcement from lots of angles, state and federal. And so entities are already thinking about these issues and concerned about them. And when they address them, they want to do it comprehensively. They want to make sure that what they're doing is compliant with every law that applies to them, because if they're going to take the effort to address these issues, then you should do it right. And that's appropriate and it makes sense.
I guess I get that for compliance generally, but if in fact there's an overly restrictive interpretation, that surprises me if there hasn't been aggressive enforcement. So, you don't want to get a speeding ticket, it's going to ruin your insurance rates. So we generally want to comply, but most people figure, I can do that 10 or the 9 miles because they're not going to pull me over. So why aren't we having the 10 or 9 mile interpretation with respect to Part 2? And in fact, we're having the drive 20 under the speed limit. I'm just curious why people are so hesitant here if there hasn't been any enforcement. I'm not that you would know the answer. I'm just curious. That's where my head is.
I mean, the only thing I'd layer on that maybe provides some insight into this, we've talked about overly restrictive readings, but I mean, the reality is if you start at the baseline of what the statute and regulations require in Part 2, it is just extremely restrictive. It's way more restrictive than HIPAA or pretty much any comparable state law. There are some state laws that are just as restrictive, but I think that's where people are coming from. And yes, we're having these conversations around the edges of, are we misinterpreting or are we applying it too restrictively? But those are just around the edges, and the reality is the core of the law is extremely restrictive, and people pick up on that and understand it.
Pamela, did you want to say anything?
No.
No? Okay. I think I see a mic in somebody's hands, right? Where did I see a mic?
Mary Graham, Great Lakes Health Connect. The only reason that I'm about to comment is that I started out in mental health in my career, and so I cut my teeth on the mental health code, and then I moved over to the health plans, and that's when HIPAA came in place. So I'm dating myself, obviously, but by the same token, the thing that struck me about HIPAA was that it seemed so easy compared to the mental health code, because the mental health code was so very restrictive. And the mental health code, I think, was put in place to some great extent because of our professional standards of conduct. We're talking about how social workers, psychologists are trained in what our professional codes of conduct expect from us relative to confidentiality, which is different than law. Ethics and law are not necessarily the same thing. And so I think that when we look at those things, we're all functioning from a different perspective, and we bring those perspectives to our interpretation. And obviously lawyers are going to be risk averse. They don't want their clients to have to pay, to cover them. So you have 3 different professions really in play here, and more than that, because the legislature as well. But everyone's coming at it from different perspectives, and those interpretations become complex because of that. Mm-hmm. And I think that's one of the barriers we have between what we're seeing with the changes to the mental health code and the interpretation that Dr. Waller is somewhat confounded by, and all the different ways the CMHs are having to function with their legal counsel, and then HIPAA on top of that, professional conduct on top of that, so on and so forth.
And I'll just say from New Jersey, I used to regulate licensed professionals in New Jersey, and one of the things that we uncovered in the work we did in New Jersey looking at the privacy laws was how many variations there are in the regulations that govern the various licensed professions, and there are far more than 3 in play. And there are undefined terms, there are different terms. Sometimes it's physician, sometimes it's medical professional. There's so much lack of clarity and understanding. And as I said, in many instances, the state provisions predate HIPAA, so the variations are not necessarily intentional. And so New Jersey has now undertaken, the Attorney General's office is looking at, it's having its professional boards get together and meet and think, okay, what do we say on the books? Do we have to use that language, or is that just a legacy? We can use the HIPAA language because it's actually the same goal, and we're going to have consistency. Make sure that every variation is intentional and not just an artifact. And so I think that's something that each state can do to make sure that, do we need to have variations? Because sometimes it's not, there's no deliberate attempt, it's just they grew up and the variations cause confusion and make it really easy for risk-averse attorneys to get nervous. Did you have anything you wanted to add? No? Okay, how are we on time? Yeah, okay. I thank you all very much for your questions, and I thank you so much for bringing your expertise to the panel. Thank you.